regard to evictions, and I'm not sure if this is something you would like to answer, Governor, or Secretary Pryor might want to answer for both of you. But a lot of the criteria for eligibility in the prior housing help programs were structured so as to, in practice, and obviously this was not the intention, it's contrary to the intention, to exclude a number of people in poverty. For example, in order to participate in the housing help program, you had to have a lease. So people who were on month-to-month were simply ineligible. And of course, the probability of somebody being on a month-to-month arrangement rather than having a formal lease is much greater if they're in lower income and lower cost situations. But what are you planning to do with that and the new program, the Safe Housing Help Program?
Couple responses to that. First of all, there are federal rules that attach to the use of federal funds. So you're speaking of Housing Help RI, and there are some strict structures that are associated with the use of the funds that we've drawn upon for the purpose of ensuring accountability for the use of federal dollars. The demonstration of a lease is such a requirement. For the new eviction program, we are providing flexibility that pertains to the kinds of cases that can arise and be assisted through the program. For example, under Safe Harbor, a 5-day demand notice can be the starting point for eviction proceedings, even though you're not yet in formal eviction dialogue and before the court. So we're going to start the program, enable it to start with the partnership of the United Way and the District Court, even at the 5-day demand letter point in time. As a matter of fact, because Chief Judge LaFazia has been just so terrific in partnering around this, at her initiative, the court will actually be enabling the sending of information regarding the new Safe Harbor program when the 5-day demand notices go out. So that's an example of how creativity and flexibility are enabling more people to be involved. If you simply waited for the moment of eviction, you'd lose great numbers of Rhode Islanders who would already be in trouble and would not have anything to resort to. So we are being as creative as we can within the federal rules. As the governor said, the big point to be made here is that we need to do much more than waiting for folks to be in distress. We need to build out our affordable housing in Rhode Island so that there are more affordable opportunities for Rhode Islanders, for people in poverty, for working families, and beyond. That's why the governor has introduced an affordable housing plan in which across income strata, where there's distress pertaining to the obtaining of housing, high quality housing, accessible housing, affordable housing, we would be producing more and preserving more units that are affordable for Rhode Islanders. And as a reminder, the governor's plan includes bond money for the production of units, and it includes the first ever in Rhode Island history dedicated funding stream for the purpose of production and preservation of affordable housing. Every other state in New England has a dedicated stream in its operating budget. Rhode Island doesn't, and we're aiming to remedy that during this legislative session.
Are you saying, though, that the $7 million in the new program would be under those same federal restrictions?
No, different, but with the maximum creativity that I've just described, able to reach more cases.
Follow-up, is the free legal help available only to those who apply and are accepted, or is it available to anyone who needs free legal help in court?
It is, I see what you're saying. A tenant or a landlord needs to opt into the program. They can do so very easily, though, by calling 211. And even if they've gotten a 5-day demand notice, a tenant may get involved. So that's the low threshold for involvement.
Does the landlord have to agree to that?
They do. They do.
So why would a landlord agree to a free lawyer for the other side, given that right now they have all the power? They've just given up a huge advantage.
One of the reasons is that I don't want to overstate or understate the court's involvement. The court should speak for itself, but the court and we are simultaneously providing this information as a gesture and as an indicator of what we collectively believe is the right path for many of these cases, which is to try this informal method of, you might call it informal mediation. It's shy of formal mediation. So both tenants and landlords would be well advised to follow the pathways that are being recommended by both the executive and the judiciary branches in that sense. Not a formal recommendation from the court, but those would be among the reasons.
But the court's saying they don't get the 5-day and 30-day notices, so how would they use that to communicate?
It is true that your pre-adjudication, when you're getting one of those notices, the 5-day notices, and that's actually ideal, because what you want is the attorney representing the landlord to be forwarding this information with the 5-day notice, and that's what the court will be requesting of attorneys that appear before them. So this is better than the court's involvement in that you are in advance of the court having to be involved at all in the case. By the way, if there is an eviction proceeding, safe harbor also works, and then you'll be in the midst of the court proceeding, and presumably a judge, this is up to the judiciary branch, I'm not prescribing in any way, shape, or form how the court does its business, but presumably the judge would request to see the results, if you were in the midst of an eviction proceeding, of this attempt.
But the lawyers are not required to do it, they're requested to send it.
Correct.
So there will be some tenants who will not get this information, theoretically.
Correct, and what you're pointing out, well, the likelihood is very high that the information will be out there, and one of the things we're doing today is ensuring that it's even more widespread than individual notices. But having said that, you're once again pointing out something that gets to the governor's bigger point, which is we may need more legislative measures to remedy the eviction problems endemic to Rhode Island and frankly facing the rest of the country, but let's focus upon Rhode Island. There may be other legislative measures that we need to consider if landlord cooperation and tenant participation don't work out to be optimal. If we're not seeing this work as effectively as we all collectively hope, we might have to do more, and it might have to include some legislative remedies. So let's let this program play out a bit. Let's see if it does work. We're optimistic that it will help a number of cases, and then we may have to turn to the legislature.